Hi, this is Jim Cunningham. We're going to talk about what is probate, and we're going to unmask the hidden threat to your estate. I will tell you, probate is something you should take very seriously if you're concerned about the peaceful transfer of wealth from one generation to the next. Typically, is what we're talking about. We'll talk a little bit about what happens with spouses. But what we're talking about here is when somebody passes away with a will or without a will, what happens when someone dies without any planning? We're going to start with that. So if you die without a will or without a living trust, or if you're watching this video because you've gone to a bank or, a realtor or somebody, and maybe one of your loved ones has passed away, and that person did not have a plan, which by the way, about half of Americans don't have a plan. So don't feel like, something's wrong in your situation. But you may have been told, oh, you have to go to probate to sell the house, or you may have to go to probate to get access to the bank account. We're going to kind of walk you through what's involved in this process. So ideally, you want to avoid probate, but if you're in it, we kind of want to walk you through and unpack what really is going on here and what to expect. And frankly, it's a lot in most situations. But if somebody dies without a will or a trust, that is called intestate succession. So intestacy, without a testamentary document. So intestate means without in this case. Intestate laws means without a last will and testament. The term will is from the Old English villain, meaning to wish. So it's my wishes. Testament is from the Latin testamentum, meaning a will. And what happened after the Norman invasion in 1066 of England is you had the French-speaking Normans who were ruling the English-speaking Anglo-Saxons. So you will hear like cease and desist, last will, and testament. That's both the Germanic root and the French root. So in English, it's not uncommon to be slightly redundant. So that's why we use last will and testament. That's the historical origin. Your assets need to belong to somebody else. So in my book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer, this is one thing right out of the gate in the very beginning of the book. When you die, your earthly possessions stay here. They don't go with you. And I know that's obvious and it's, duh, Jim, like, hello, tell me something I don't know. But really, if you stop and think about it, well, how does it get from you to who you want it to get? What is your wish? What is your villain from the old Germanic? What is your will, right? Who gets these assets? What is the process for them to get the assets? And I will tell you in California, it's quite a process. So typically, this typically subjects your loved ones to the probate process. And it is a real pain in the neck. And I will tell you, it's expensive, it's time consuming, it's emotionally and mentally difficult. I've been through this with clients through the probate process. And if you're watching this on YouTube, we have a little bit of clips from the movie Zootopia. And I don't know if you remember, like the rabbit and the fox show up at the DMV, and the DMV people are moving really, really slow. This is what probate is like. So if you're watching this on video, these people are moving incredibly slow. And it's really, what is probate? It is the DMV of the afterlife for your money. You take a number, shuffle through endless forms, let a judge stamp everything, and only then do your heirs get to leave with the keys to everything, right? To your wealth. But this is after the meters run, and there's a lot of legal fees that we'll talk about. So a little bit of humor there on the slowness of the process. But I'm using this humor because this may be a difficult and painful subject for you watching this. And I want you to know that I'm not minimizing this, but I'm just trying to bring some humor in to make it a little less painful, hopefully. So what we're going to talk about is what is probate court? What's going on there? What does the probate process look like from start to finish? We're going to talk about that. How does a living trust work with this? Because you may be watching this video and you say, gee, mom and dad had a living trust and I still have to go to probate. What's the deal with that? Well, if the house should have been in the name of the trust and it wasn't because maybe mom or dad refinanced or they for some reason took it out, if that's not in the trust when mom and dad die, you're looking at probate court. Okay. And I hate to break the news to you, but in many situations, you're going to be looking at probate court. And really the next one is, how do you start probate? And if you've started it on your own, or maybe you started it with a lawyer and that lawyer died or retired, or kind of you can't find the lawyer anymore, which happens from time to time. How do you finish that process? Certainly if you've started it yourself. If you're watching this on YouTube, please subscribe to our YouTube channel And we have a lot of content on there. And if you're watching this on our video, please check out, or if you're watching this on our webinar, please check out our YouTube video. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have 30 years of experience as a lawyer. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, a real estate broker, securities and insurance licensed, and a pilot single engine land instrument rated, not current. And these are the attorneys in our firm. We are dedicated to all things peaceful transfer of wealth from one generation to the next, while minimizing taxes and protecting the inheritance for your loved ones from creditors, predators, and divorce. You know, the future ex-son-in-law and future ex-daughter-in-law. We're very, very mindful of that. This is a disclaimer. It's very important. When I use the term you, there's no attorney-client relationship. Please don't watch this video and just go out and do a bunch of stuff on your own, you know, because I said so. It's a bad idea. You need a lawyer, whether it's us or another firm. You should have some competent, savvy legal counsel. So why should a person understand the probate process? Because if you don't have an estate plan, your estate will likely go through probate when you die. And if you don't have an estate plan and you own a home and a bank account or even just a car in your name, you're in the game. Your estate's going to go through probate. You're typically facing this probate process, and probate's a little bit like quicksand. If you don't know where it is, you're going to stumble right into it. And if you don't know, if you do know, you can build a bridge over it, right? And that's exactly what smart estate planning does. Is we know it's out there. We know everyone. We are born and we die. That is the fundamental human experience. After we pass away, our stuff stays here, and that stuff has to go somewhere. It's going to go to your loved ones. It's going to go to maybe your future ex-son-in-law or future ex-daughter-in-law if it's not planned properly. It might escheat to the state, meaning pass to the state of California. You know, they've got enough of your assets. I don't think anyone wants that. But without proper planning, all of these are possible outcomes. So avoiding probate, by the way, is typically the smarter move. So if you've heard about probate and you're not quite sure and you want to plan your estate, and maybe you're looking at a will versus a trust, please understand that a will does not avoid probate. A will is a one-way ticket to probate court. A living trust in California is the way to avoid probate. So let's talk about what is probate. The legal definition of probate, and this is right off the Placer County Superior Court glossary. So in doing research for this, California has 58 counties and they all typically have their own website. And this is not a helpful definition, let me tell you. The County of Placer defines probate, and Placer County is just east of Sacramento in Northern California, is the judicial process in which an instrument purporting to be the will. What does that mean? All right. The judicial process in which an instrument purporting to be the will of a deceased person is proven to be genuine or not, lawful distribution of the decedent's estate. An instrument purporting to be the will. This is very important to understand. A living trust is a valid binding document the moment it is signed. When somebody creates a will, that is a valid legal binding document only after two things happen. The person writing the document dies. Secondly, the probate court accepts this as the decedent's last and true will. So their last will and testament. So you might have done a will 10 years ago, then 5 years ago, and then a year ago, and then you die, right? The last will you did, and that's why we call it last will and testament. The last one in time is the one that holds up, right? Most wills say, I revoke all prior wills and codicils, and a codicil is an amendment to your will. But it's very important, if you're facing probate, if you have this will, having this will does not avoid probate. You're going to have to go through that process. And really, that's why the banker or the realtor might have told you, you need to go through probate in order to get your name on the deed or your name on the account to deal with the property. So they continue with the probate definition as the legal process of administering a will. What the heck does that mean? The legal process of what is administering a will? Well, administering a will is includes the judicially supervised process for marshaling. Now that's a new word. For marshaling a decedent's assets, paying proper debts, and distributing the remaining assets to the persons or entities, like charity, I guess, entitled to them. An estate may be probated even if there is no will. So in the absence of a will, this is what we talked about earlier, intestacy. In the absence of a will, those assets pass pursuant to the laws of intestate succession. So California, if you die a California resident, they have intestate succession. If you die a Texas resident, Texas has its own laws. So it's very important if you move from one state to another, the laws are different. Now, they're similar, but they're not the same. And it can be very complicating, or it can be a lot more complicated if you're living in California, then move to Texas, but you own real estate in California. Now you're a resident of Texas and you die, what law controls? That's a very interesting question, right? And so I'm not going to use the lawyerly answer of it depends, but each state is going to have a say on who inherits what. So it's very, very important to understand that where your domicile is becomes much more important. A living trust kind of resolves a lot of these issues, quite frankly, in a way that a will doesn't. So what is marshaling? It's a very interesting word. So you don't hear this too much in the English language. So I actually went to where everyone goes now, ChatGPT, and said, what is marshaling? The word marshal comes from the Proto-Germanic marhas, which means horse, and skalka's servant, meaning horse servant or groom. This word passed through Frankish and Old English to marshalk and mareschal, and then to English after the Norman conquest, as I mentioned before, to describe a high royal or military official. The modern verb to marshal retains the sense of arranging or organizing stemming from the officer's role in command and order. Now, this is very, very important. An officer in command is subordinate either to like the president of the United States ultimately, or a monarch, right? A king or a queen. And this term commander or marshal is a subordinate to the probate court. So the probate court is the one that supervises the court process. It's the executor's job to marshal the assets, and they have a very broad authority. So they're in charge. That executor is in charge of the probate proceeding, but is subordinate to the probate court. So that the scope of the authority that an executor has in marshaling the assets is limited by statute. It's limited by whatever the court order says, but ultimately a judge is going to pass on the acts of the person marshaling the assets. So I don't want to get too in the weeds on this, but marshaling is very important because we also marshal assets in a trust administration. So after somebody passes away with a trust, there's a similar process of organizing or collecting all of the assets, hence the English word marshaling. So the legal definition of probate, as explained by an attorney, this would be me, probate is the court-supervised process of proving a will, meaning the judge saying, yes, this is the decedent's, which is the dead person, the decedent's last will and testament, if there is one, or deciding who gets the assets, where they go to if there is no will, and that's the intestate succession. So it's ultimately the probate judge who ratifies all of this. Now, I have heard a probate judge say that a will is merely a wish list for a probate judge, and I've seen a probate judge years and years ago. The will called for the euthanization of this decedent's 10 dogs. Now, if you can believe this, this is a horrible thing. The judge asked the executor, and I was there in court. This is when people used to go to court in person and not on Zoom. And the executor asked or the judge asked the executor, how many dogs have you put down? I put down 5 dogs. We've got 5 more to go. The judge stopped. He says, I'm ordering you as executor not to euthanize those 5 dogs. And why don't you bring them to the court? And then they had those 5 dogs were adopted by court staff later, which is, it's great. If you're a dog lover, great result. But I want to mention that because just because your will says to do something, a judge can say, well, I don't like what you're doing, and I'm not going to let it happen. And there's really there's no appeals process, meaningful appeals process in a case like that, because that discretion is often exercised by the trial level or judge on the bench in the matter. So just something to understand. The reason I tell you that story about euthanizing the dogs is to know that a living trust does not get that kind of a treatment. A will does get that treatment where the judge says, I don't like this term. Right. And because the judge has to affirmatively ratify the terms of the trust, whereas with ratify the terms of the will and say that the will is the valid last will and testament. On a trust, the court does not have that type of authority. So probate gives someone the authority to manage the estate, make sure the debts and taxes are paid, and this includes creditors. We're going to talk about that more. Creates instructions to distribute whatever's left to the rightful heirs or beneficiaries under the will. And if there's no estate plan, again, it's likely to go to probate. And the most common reason that people go to probate is intestate succession or having a will, right? So if you have a trust, a lot of times, if it's properly set up and maintained, it does require a little bit of care and feeding. Just want to make sure that those assets that should be in the name of the trust are, and you can stay out of probate. So what is intestacy? Intestacy is dying without a will. It is the condition of a state of a person who dies without having made a valid will or other binding declaration. Now, a person may have made a will, but it did not meet the formalities, right? A will has certain formalities. Oh, this is how you should not write a will in California. You're a California resident. You write a will. You sign the will, and you have a notary acknowledge that will, right? You have that will notarized. That is not a valid will, right? That has to be witnessed by two people, one of whom must be a disinterested witness, meaning they're not named in the instrument or inherit. So it's one of these things where sometimes people make a will and then they realize, oh, well, it's not a valid will, right? Or maybe they handwrite something, and the way it's written, the words that are used in that document are not sufficient to constitute a will. That's a big source of litigation. So if there's no will, we're talking about intestacy. So this is a distribution of the decedent's. The distribution of the decedent, this is the dead person, the decedent's assets are determined by state laws known as intestacy or laws of intestacy. California intestacy law prioritizes the distribution of a decedent's estate to close relatives, including your third cousin thrice removed. If you have been cohabitating with your partner for 40 years, that person is not on the table of consanguinity. Okay. I mean, theoretically they could be, but what I'm saying is there is no common law marriage in California. So if you've been cohabitating with someone, your life partners, maybe you tell everyone, oh yeah, we're married, but you're not actually married, or you're not now a state registered domestic partner, which is kind of a different topic. So if you're a registered domestic partner, but you did it with a municipality, a city or a county, you may want to double check, and you may want to get that registered with the state. There's been some movement on laws on this, so something you'd want to double check. But table of consanguinity, what is this? This defines relations. So you have the deceased person. They can have children, grandchildren, great-grandchildren. They can have grandparents. Well, a descendant of a grandparent is an aunt or an uncle or a first cousin, and then a first cousin once removed. And then a descendant of a great-great-grandparent could be a third cousin thrice removed. I've never gone down third cousin thrice removed. I haven't made it that far, but we have gone down to descendants of great-grandparents in intestacy matters. And it's kind of hard to track these people down without a will. First of all, you're going to have to track these people down on a probate anyway, because they get notice of the probate. But a person whose parents are deceased, has no siblings or descendants, and no descendants of grandparents, we may have to go out quite a ways on that. And so that can require actually hiring a private investigator, which has happened in the past. But this can all be cured with doing a living trust, right? So we can take care of this. But you're not even going to be able to start probate, by the way, until you find these people. So because these people are entitled to notice before the executor has authority to act on the estate. So let's look at a simplified version of California intestacy laws. If you have children but no spouse, the kids get everything. If you have a spouse but no children, right? So you're married, but you don't have kids. You're an only child. Your parents are deceased, no siblings or nieces or nephews. Your spouse gets everything. If you have parents, right? But you don't have children, spouse or siblings, so you're not married, no children, your parents get everything, or surviving parent gets everything. If your parents are deceased and you have siblings, brothers and sisters, but no children, spouse, and your parents have passed away, the siblings inherit everything. So you can see, depending on what relatives you have, it changes the outcome of who inherits. Now, if you have a spouse and one child or grandchild, so if you're married with a spouse, your spouse inherits all of your community property and one half of your separate property, meaning the child or children split, or your child inherits the other half. If you have a spouse and two children, your spouse gets all your community property, but only a third of your separate property. Now, I'm mentioning this, and then if you're a spouse and parents, your spouse gets all your community property and half your separate property. So if you have no kids but parents, the parents get half. I got to tell you, a lot of times people do not want this, right? They don't want their parents to get half. They want their spouse to get everything. Well, then you got to make a will, or you have to make a trust. And if you have a spouse and siblings but no parents, your spouse gets all your community property, half your separate property, and then the other half of the separate property goes to siblings your siblings. Now, I will tell you, having been married for a long time, most people do not want that outcome. Most people would want their spouse to get everything. And this also begs the question, well, what is community and what's separate property? It's very important to understand that all property acquired during marriage is community property, except property acquired by gift or inheritance. And all property brought to the marriage is separate property. But whether you inherit or are gifted or bring property to the marriage, it is very, I don't want to say easy, but it is very common and for separate property to be transmuted unwittingly to community property. Okay, so I'm not going to get too much into this. Just understand that if you have separate property and you're married, your spouse isn't necessarily going to get everything unless you do a will. So it's very important to understand that state laws of intestacy are typically not your friends. So let's look at Prince. One of my son, who's a great musician, a little bragging there, I suppose, but Prince, big fan of his, $156 million estate when he died April 21st, 2016. No will, no trust, if you can believe this. Now, it's actually hard to believe that you would think somebody who had his life together that much to build this huge brand and make movies and albums and have a very successful music career didn't even do a will. Like it's kind of shocking. 45 people allege they were related to Prince. His siblings spent $3 million in false creditor inheritance claims, and 3 out of 6 siblings sold their shares of the estate and the rights to his music just to be able to liquidate the assets, right? They had to settle an $84 million tax bill and pay legal and court fees without being able to touch their inheritance. So they had to pay all of these expenses before getting $1. Okay. So the estate had to be settled. It took 6 years and over 2,700 court filings, DNA tests. And by 2019, the estate had incurred $45 million in legal fees. So you add 84 million and 45 together. It's still leaving, tens of millions of dollars, but it's nowhere near the 156 million. Now, are there things Prince could have done? Absolutely. Did he do them? No. Half siblings, some little interesting questions that pop out. The half siblings, there's a 120-hour rule. What if you have no heirs and personal representatives? It's very important. Half siblings are treated the same as full siblings for inheritance purposes. So, and this may take a while for it to soak in, but it's not that, if you have a half sibling, they are a sibling. Okay. And that's not, that may take a while for that to set in. So we'll just leave it there. If the beneficiary, meaning if somebody dies and maybe the brother's going to inherit everything, if that brother dies within 120 hours of the decedent, which is 5 days, they're deemed to have predeceased the decedent and not entitled to the inheritance, unless there's no other surviving kin available to inherit. So there's also this 120-hour rule. So like if someone's traveling and they're in a car accident and one person dies in the car accident and the other one dies a day later from, maybe the injuries from the car accident, the second person dying is deemed to have died before the person who died first, if you can get your head around that. So it actually makes sense if you kind of take a deeper dive in a hypothetical. It's just something to understand, because this does come up. Like, well, what if someone dies close in time? If there are no heirs, the estate escheats or goes to the state. Now, this is if you cannot locate any relatives. I've never seen this happen in practice, although it does happen. I don't know how much it happens, but typically we're able to find somebody somewhere. Although we did have one client who was born in Russia in 1905 and did not leave a will. And Russia in 1905 encompassed most of Eastern Europe. So we just couldn't find any intestate heirs. And we had a separate resolution on that one. Personal representative, there is an order of priority for who can serve as the personal representative, and that's outlined in California Probate Code Section 8461, with the surviving spouse or registered domestic partner being first in line. Now, this is even if you filed for divorce. Let's say you hate your spouse and you filed for divorce, but the divorce is not finished. You should think about doing a will, because if you die, your spouse still inherits everything, and your spouse is in line to handle the affairs of your estate. So again, if you're divorcing, and unfortunately, in my experience, I've seen many people who get an illness, cancer, some other type of illness, and that they get divorced during that. And I don't know why, but I've seen that several times. It's very important that once you filed for a divorce in California, there's something called an automatic temporary restraining order in the divorce decree, meaning if you have a living trust, you may not be able to amend the trust, but there's some other things you can do to change who gets your property when you die. You have to thread the needle on that and be very careful. So if you're watching this and you're in the middle of a divorce and you're concerned that you might not survive the divorce, there are some things that you can do. But you got to tread carefully on that. And that's something we've helped many clients out with in the past. So let's go back to the legal definition of probate. The superior court in the county where the decedent lived handles the case. What does that mean? Well, if a person lives in LA County, but owns a home in Marin County, right? Maybe they rent an apartment in LA, but they haven't sold their house in Marin. You're going to file in LA County. So you're going to have an LA County judge deciding or passing on the acts of all this stuff that happens in Marin County, several hundred miles away. Probate's generally triggered if the estate is worth more than $208,850 as of April 2025. There is a small estate affidavit. So if the only thing that the person has, if they've died April 1, 2025 and later, if all they have is $200,000 in a bank account, you are typically able to do an affidavit under Probate Code Section 13100. This keeps you out of probate, right? But if you have $209,000, you're in probate. The small estate affidavit is a shortcut that lets heirs collect a decedent's personal property, not real estate. We're not talking about real property, without going to probate if the estate's under $208,000. So if you have an IRA of $1 million, that doesn't count because IRAs pass by beneficiary designation. If you have a life insurance policy of $1 million, that goes by beneficiary designation. If you have a bank account of $10,000, you can do the affidavit. Even though the estate's over $1 million, when you look at everything, there's no probate because of the nature of the assets, because some of those pass by beneficiary designation. But this is only personal property. So cash, bank accounts, stock, maybe stock account, maybe you have Charles Schwab account or something. Vehicles get separate treatment under the California probate code, not for real property. We're going to talk about this. And you have to wait. Jesus was in the desert for 40 days and 40 nights, and Noah was on the ark for 40 days and 40 nights. So must the people who take under Probate Code Section 13100 wait 40 days and 40 nights. I don't know why it's not 30. Don't know why it's 40. You can see their law has a lot of historical holdovers on it, right? And you can't do this if there's an open probate matter going. So you can't open a probate and do this. It's not an option. Now, what if you have real estate? Now, this is what if you have a home? This is a new rule. This is effective for deaths April 1, 2025 and later. Now, this is very important because you may have found us on doing a Google search or an AI search that's led you to this segment of the video. This is very important. And it's very important to understand that this is a huge change in the probate process in California. Half the homes that people own when they die, and this is your only your primary residence, half the homes are $750,000 or less. Now, you may live in an area and you go, I don't think anything around me is $750,000, but there are a lot of condos. There are a lot of smaller homes. There are a lot of homes in more rural areas, less coastal areas that just simply do not have a market value of $750,000 or more. So if this was Assembly Bill 2016, not from 2016, but Assembly Bill 2016, what this says is this allows you to do a single petition for the residents only. Now, you can have other assets. You could have $1 million in other assets. This allows you to bring a petition to determine succession to real property for the primary home up to $750,000 in market value. Okay. This only applies to the decedent's primary residence. So this is the homeowner's exemption, or eligible for the homeowner's exemption. If it's a rental, not the primary residence. If it's a commercial property, not the primary residence. This is where the person lives, right? Where they sleep at night, where they have Thanksgiving. It's their house, right? So not a vacation home, not these other properties. And this is the decedent's main home, even if they weren't physically living there at death. Now, if a person's in a healthcare facility and it's not being rented out, now if it's being rented out, I think it probably doesn't qualify. So if a person says, oh, I got sick, and then they go to a care home or nursing home and maybe die a month later or something like that, and the home is 750,000 or less in terms of market value, you're going to be able to not avoid probate entirely. You have a single filing, and there's some other requirements. You have to notify heirs within 5 business days of filing the petition. So you file it, you got to notify them within 5 days, and it's only eligible for deaths April 1, 2025 and later. It does require some court process. It requires DE as in decedent's estate 310 and 315, a probate referee. This is not a person with a striped shirt and a whistle. This is appointed by the governor in each county. Each county has at least one probate referee. Their job is to value property for the state of California, basically, and this includes probate proceedings. So if a person dies in LA County, you're going to want to get a probate referee in LA County, and you would have this this inventory and appraisal valuation of the property, and it's got to come in at 750,000 or less, and that's included in the petition that's filed with the court. So if you don't have that valuation attached, you're not going to get your relief. You have a court hearing and a judge's order. Again, notice is required to be sent out 5 days after the petition is filed, and if you miss this deadline, the court may not have jurisdiction to give you the relief you want, which is the order transferring the property to the people who are to inherit it, right? So if you got 5 kids, $750,000 house. Okay, so you've avoided probate. Now 5 people own a $750,000 or $600,000 house. Those 5 people have to agree on a lot of stuff. They're also responsible for the debts of the decedent. Well, what if 4 of them, you sell the house, 4 of them blow the money, and there's this one last person stuck who's the responsible one, and a creditor comes forward and says, hey, I'm owed $250,000. Well, that person didn't even get $250,000 if they're a 1/5 of 750. They may be responsible to pay that creditor. So this is not, I don't think this is a solution to probate. I think it's very well intentioned. Also, if you have other assets beyond $208,000, you're going to go to probate anyway. There's a lot of problems with this. So if this is you, I would not just say, hey, great. Mom and dad had a house of 700,000. I got 3 siblings. Great. We'll just do this and bypass probate. You're going to have some other issues you're going to have to deal with. And a lot of it has to do with the creditors. So if the property's not a primary residence, even if it's valued under 750,000, you can't do this. You're still on the hook for formal probate. And this is based on the fair market value of the property, not the equity in the property, and not the assessed value. So mom and dad could have a home worth 750,000, and we cover this so much in other videos. Their property tax bill might say the property's valued at 200,000, right? We're not going off the assessed value, we're going off the market value. So if the market value is $1 million, but this assessed value is 200,000, you're not going to be able to use this proceeding. You're going to be stuck in probate. Yes, with the small estate affidavit, you still only get the 208,000 limit for personal property. So you could theoretically have a house of 750 and 200,000 in cash and use 2 separate proceedings or 2 separate processes to avoid probate. Whereas before you couldn't do that. Before, if the death occurred before April 1, 2025, you would have been unable to do that. So in certain areas of California, I would say the San Francisco Bay Area, Los Angeles, Orange County, San Diego, 750 doesn't buy much. It might get you a condo, maybe a 1-bedroom condo. The median home price statewide is already hovering around 900,000. So I would say, you can go on Zillow or wherever, Redfin, and put in the address of the property. And, if it's 1.1 million, this is just not going to be available. If the property, if Zillow or Redfin or whatever you're using says the property's worth 760, probably not a bad idea to contact the probate referee and, say, hey, is this something that we can get valued at 750 or not? What is the real value? You go through that valuation process. But that's something I would certainly take a look at. So again, here's how it falls short. It's an example here. Mom's Pasadena home she bought for 300,000. Now it's worth $1 million since it's over 750,000. The family's forced into expensive, full-blown probate. Dad's $650,000 Auburn home qualifies, but 300,000 left in his retirement account exceeds 208. Maybe it's just a money he set aside for retirement. And so maybe 300,000 cash. Those 2 numbers put together are 950. Then you're stuck with probate. Now, if that's in an IRA, right, that goes to people, then then that's not a probate asset. That 300,000 is not a probate asset, and you could go through this truncated or shortened probate process. If uncle's home's worth 900,000, but he owes 800, the gross value counts, not the equity. So it's over the $750,000 limit. Probate's going to be required. So this is not the silver bullet for people, but if this is you and the home is under 750, I think it's worth an analysis. Does it make sense to move forward with that truncated, shortened process, or does it make sense just to go through the full-blown probate anyway? There are a lot of reasons. Another reason to go through full-blown probate is you're not, as the recipient, as the beneficiary, you're not responsible for any of the creditors of the estate. And that's very, very important, because you don't necessarily want to be on the hook for that, right? Because you may be jointly and severally liable, in the sense that just because you inherit 100,000, if the estate's worth 500, you may be on the hook for the full 500. So that's something really to take a look at. So when does probate happen? If there's a will, the will gets filed with the court after death, not before death. If the person has not died, the court's not going to accept the will. The court goes through its process to ensure the validity of the will. Debts are paid before assets are distributed. I cannot stress this enough. A lot of times people say, well, once I open probate, can't I just write the checks to the people? No, you've got to hold that money back. You can only distribute that money after a court order in the state of California. Other states are different. Okay. Other states have not as much judicial supervision. California, heavy judicial supervision. Spoiler, a will does not avoid probate. One of the most common misconceptions out there. Again, I know I've said this already, but a will absolutely does not avoid probate. Now, if there's no will, this is what we talked about, intestate succession. The court follows California state law to decide who gets what. This can mean distant relatives inherit rather than the people you actually want. Maybe your friends. Maybe your partner, the person you've been living with, who you've created a life with. Maybe your stepkids. Maybe you have a partner and you don't have kids, and your partner has 2 kids, and you really want your estate to go to those 2 kids that you kind of feel are your kids. You have to do an estate plan, folks. You have to do a valid will or trust, preferably the trust. The messier the family, the riskier things become. If you're a blended family, if you're 2 spouses and each of you has children, and one dies and the other inherits, right, as spouses, let's say it's all community property and the one spouse inherits, and then that surviving spouse dies, that property is going to that surviving spouse's children, not the children of the first spouse to die, right? So in a Brady bunch, if Mike Brady dies, Mrs. Brady doesn't do a will. She inherits everything from Mike. It's going to her 3 daughters. It's not going to any of his 3 sons. So very, very important. If you have a blended family, please pay close attention to this. When is probate necessary? No fully funded living trust. If there's only a will, when there's no will, when the assets, now for 2024, it was $184,500. For deaths, April 1, 2025 and later, it's $208. Probate's the only way to sell, dispose of, or otherwise transfer those assets. What is the number one reason why trustees should get a lawyer? If you have a living trust, or you're the trustee of a living trust, and you heard about probate, and you go, I have this living trust, and they're telling me I have to go to probate, you really need a lawyer. People who serve as trustee, people who serve as executor, have unlimited 100% personal liability for everything that goes wrong. And spoiler alert, you typically don't get credit when things go right. If you own 2 stocks, one goes down, one goes up, you're personally liable for that stock that went down. That's black letter California law. Now, in the real world, does that happen? No. People do an investment policy statement. That's one reason to hire a lawyer, right? That shields you as a fiduciary. The judge doesn't care if you're grieving, confused, or trying your best. If you miss a filing date, botch a notice, or mishandle a creditor's claim, and the whole case can stall for months, or worse, you can be held personally liable for things that go bad. If you forget to publish notice in the right newspaper, you're going to have to start up. So probate requires a filing of a petition and then publication of the petition in a newspaper. Paper, ink, the real deal, not online. This is, when's the last time you saw a newspaper, right? Requirement that it be published in a newspaper. Good luck finding one. Did you file your inventory too late? Right? In a probate, you have to value the assets. The California probate referee values those assets. That has to be timely filed. If you don't timely file it, the judge can sanction you, potentially remove you. What if you miscalculate fees or taxes? What if you don't pay the taxes? The judge is not going to sign off on distributions until you get a tax clearance certificate from the state of California, meaning the decedent paid all their taxes. You do not have that requirement with the trust. So a lot fewer requirements for a trust, significantly heavier lift with a probate, significantly more cost, and we're gonna get into that. I mean, example here is if you distribute funds, then a $20,000 hospital bill shows up, you pay that. You know, if you've distributed those funds and you haven't done your job, you're personally on the hook for that debt. So the probate court is not built for amateurs; it's built for lawyers. What does a California probate process look like? Well, in California probate process says, this is what the law says: person dies within 30 days, the will must be lodged with the court. What does that mean? That means the original will must be tendered or given to the clerk of the superior court in the county of the decedent's residence. So if a person is a resident of Los Angeles County, you've got to give that to the clerk of the court. So the lawful requirement, the original will. If the decedent died a resident of Kern County, it goes to the Kern County Superior Court. The original will has to be lodged, and the named executor needs a copy. So there's liability if this isn't done. If you don't do this timely, you may lose your position if you're the named executor, right? So 30 days is not a long period of time. Start gathering asset titles, debts, and death certificates. So you want to start marshaling the assets, right? Figuring out where they are. Now, you might not be able to yet get your name on those, but you need to identify them. You need to kind of figure out, get the lay of the land on who the creditors are, and talk to a probate attorney. This getting legal guidance is crucial, I would say, within the first 30 days. So you say, well, gee, you know, the person passed away, and then at 2 weeks of the memorial service, well, the clock starts ticking from the date of death. So pay attention to this. If this is you, if you've lost somebody, and this could be a very difficult time for you, and I get it. And there are these other requirements. So the second step is opening the case. You file your petition for probate. You publish the petition in a local newspaper, and service, meaning a copy of the petition is sent to the people who are entitled to it, and that's all laid out in the California Probate Code. This is a petition for probate, DE as in decedent's estate, 111, and choose full or limited authority. Most people are going to choose full authority under the Independent Administration of Estates Act. Limited authority, if you don't have real estate or you lack a surety bond. Basically, a will can say that I nominate Joe as executor and do not require a bond to be posted. If the will does not waive bond, a court is going to say, well, look, you need to be bonded. And what is a bond? Well, a bond is if Joe runs off with the money, the bonding company replaces that money. It's not insurance, but the bonding company replaces that money in the probate estate. Basically, Joe has to have really good credit. If Joe has bad credit, he's not bondable, or that may be a very expensive bond. And typically the bonds are a couple $1,000. So most people, when they write a will, they waive bond. That's what most people do. Generally, it's full authority, much more flexible. You can have broader authority as an executor, get more done quicker, but an attorney can help you to determine which one is appropriate in your case. I would say 95% of the time it's full authority. Then you have the hearing. So the hearing has to be, by law, the hearing has to be within the 45 and 60 days of the date you file your petition for probate. Some courts are still under a significant backlog from COVID, if you can believe it, from 5 years ago. And, you're not getting that hearing within 60 days, even though the statute says it has to be heard within 60 days. At the hearing, the judge says, if everything goes right, the court appoints a personal representative, executor, administrator with will annexed. So it's an executor if there's a will, it's an administrator if there's no will. Still a personal representative, still the same process. But the reason lawyers and judges use these two terms is if somebody says they're the administrator of the estate, we know that person, that there is no will. If it's executor, we know that there is a will. Having an attorney with you, super, super helpful. I really wouldn't do this alone. Can you? Yeah. It's like, can you build your own plane? Yeah, that's home built. My dad had a home built plane that he didn't build, somebody else built. But he thought it's better if someone else builds it. Really, this is something you want help with. because if you crash and burn, it can be pretty devastating when it comes to probate. Probate bonds are required unless waived by the will or by all beneficiaries in writing. Again, I'm not sure it's a good idea to if a person cannot qualify for a bond because they have bad credit, they're probably not the best person to be executor, but that's just a little bit of a sidebar. Again, the probate bonds a court required financial guarantee, similar to an insurance policy, but not an insurance in the sense that if someone steals the money's replaced, that bonding company is going to send a bondsman to get the money back from the person who stole it. And the bond's value is based on the total value of the estate's assets and adjusted for the credit score, frankly, of the person serving as executor. And the estate typically pays the bond. The fiduciary pays it, but is reimbursed by the estate. So ultimately, the estate pays it. Then you receive an order for probate. That's DE Decedent's Estate Form 140 and letters DE 150. And the clerk of the court stamps the letters. You want to make sure and get the purple stamp, not the black one. The purple one is the original. The black stamp's a copy. And you're going to want multiple copies of the letters. You probably want one certified copy of the order. Sometimes if you go to sell real estate, they're going to need both. And this is something you get at the clerk's window. You're not going to get from the bench, from the judge. Sometimes it can take 4 weeks to get these after your hearing. Just depends on what court you're in. It's a very long, tedious process. Day-to-day setup. So you open a bank account, you're going to get an EIN, an employer identification number or taxpayer identification number. That is the form SS4 that's filed with the federal government. That is that's basically like the social security number for the estate. You do not use the decedent's social security number anymore once they passed away, but you get this new employer identification number, and then various notices that have to be sent out. If you're selling real estate or doing other things in the estate, sometimes there are additional notices. I would say consider opening an estate bank account. So this is where you take your letters that appoint you as executor, and you take or administrator, you take those to the bank with your EIN number, and then they open an estate account, and then you can deposit checks made out to the decedent. Right. So if Jim Cunningham dies and Lori Cunningham is the executor of Jim's estate, the check made out to me can be deposited into the estate account for Jim Cunningham, even though Lori's name is on there. You send out notice of administration of creditors. This is DE 157. This is critical, absolute black letter law requirement. Creditors must be notified. All known or reasonably ascertainable creditors are entitled under the California Probate Code to a notice from the executor or the attorney sends it out, but we notify all the creditors. Jim died, Lori's the executor. You have 4 months to make a creditor claim. They make a creditor claim, you can either accept it or reject it. If that claim is made 4 months and a day later, you do not have the authority to pay that claim. I've seen a probate judge scold an executor for paying a late claim. He says, you do not have the authority to pay that late claim, right? Even though they wanted to pay it. Maybe it was to a family member, whatever it was. But there's a 4 month, as we say, drop dead, no pun intended, a drop dead date on filing those claims. That expires 4 months after the date of letters or 60 days after the notice. So if you go, well, I'm just not going to notice the creditors, they're entitled to notice. If you don't notice them, you have to later tell the judge under penalty of perjury. I have sent I've sent all notices to known or reasonably ascertainable creditors, and that's just fraud. And that, is that criminal? Maybe. But you really have to be truthful. This is very important. So in terms of marshaling the assets and marshaling the identity of the debts, this is an official, it's like you're an agent of the court. So like a marshal is the agent of the monarch or president. If they're leading an army, you're in charge. If you're the executor, it's on you to make sure that you do it properly, and you have to do it correctly. Otherwise, you're going to be held personally accountable. So you got to follow the rules. Within 90 days of the issuance of letters, some government agencies in California are entitled to notice. Medi-Cal or Department of Healthcare Services, Victim Compensation Board. This is if the decedent had committed a crime and was owing restitution, which does happen. Franchise Tax Board, right? If you got to get the clearance from Franchise Tax Board to make sure you paid all your California taxes. Inventory and appraisal, you have to file your inventory and appraisal. This is from Decedent's Estate Form 160 or DE 161 within 4 months of the issuance of letters. A probate referee, which is appointed, the probate referees are appointed administered through the state controller's office, appointed by the governor. And that probate referee is appointed by the court on the order for probate. So if you gee, I don't know which probate referee do I contact, it's going to, that box should be checked, and that name is stamped typically on the court order. That's the probate referee you want to go to. When you file the inventory and appraisal, you must also file certified compliance with Revenue and Taxation Code Section 480. This has to do with California real property and changes in ownership. If you have an LLC, so if somebody dies with no will with an LLC that owns real property, you have to notify the Board of Equalizations. Counties often don't expect, you have to notify the county of a change. So if the property's in an LLC, you notify the Board of Equalization. If the property's in a decedent's name or a living trust, you're going to notify the county assessor's office, and you got 150 days to do that. But typically you're going to want to get on that pretty quick. A change in ownership. This is very, very important. A change in ownership of real property likely will have massive tax consequences. You need to speak with an attorney before filing this. Please speak with a lawyer, because there are other time limitations. So a lot of people want to inherit the parent's home and not pay and save basically $10,000 a year on property tax. There's some forms that you have to file. So you want to engage with that lawyer early on. And there are really some drop dead time limits on here. So if you're inheriting a home, there is this process where you have to notify the assessor that mom or dad have died, in the example of mom or dad, and then they're going to reassess the property. So you need to bear in mind that that's another expense of the estate. So let's look at an example here. Jane purchases a home in LA County, Los Angeles, for $120,000 in 1985. Jane keeps the property for 40 years. Well, what has it done? It's gone up in value. And she passes away in 2025, so 40 years later, and leaves it to Kevin, her son. The fair market value, it's gone up 10x. It's worth 1.2 million, but the assessed value is 263,000. How does that happen? That's because the assessed value was 120 in 1985. That assessed value only goes up 2% a year every year. So the property taxes, maybe 1.25%, or about $3,300 a year. If it's reassessed when Kevin inherits it, the son, the taxes jump to $15,000 a year. That, folks, is a big, big difference. Sometimes Prop 19 can help Kevin keep the low property taxes. So it's something where you want to talk to a lawyer, because who wouldn't want to save $12,000 a year? I mean, it's a no-brainer, right? Step 6, consider selling real estate. If you have full authority under the Independent Administration of Estates Act, that allows you to sell real estate without a separate court confirmation hearing. Still subject to notice. There's still stuff you have to do. Limited authority usually requires court confirmation. And just think about that. You're trying to sell this piece of real estate. You have a buyer, and now you got to go to court confirmation. I mean, nobody wants to deal with that. You're much better off with full authority. Before major moves like selling homes, like selling the house, you have to give a notice of proposed action. That's Form DE 165. The beneficiaries have 15 days to object. A lot of times we'll just send a consent so that they're not objecting, after which you can proceed, or they can sign DE 166 to waive notice, right? So this is all the stuff that happens in selling. Doesn't this sound complicated? A living trust, significantly more complicated. You don't have all of these forms. You don't have the notice. You're the trustee. Much more informal. But probate is, and this is why probate's so expensive, and we'll get to how much it costs. So this is where structuring assets for distribution is critical. If you have real estate, it's actually better in some ways to sell it during the estate administration. There are too fewer warranties of title. If that property is distributed to individuals at the conclusion of probate, there are more warranties of title, and we're not really going to get into that. We cover that in other videos, but just understand, on a high level, it's oftentimes better to sell that property during the estate administration. So number 7, handling creditors' claims and bills. Creditors, if they've been served a notice because they're a known or reasonably ascertainable creditor, or maybe they're not a known, maybe they're an unknown creditor, but they subscribe to a service that pings them that says, oh, this person died, that person died, and maybe they've got this database, which I'm sure is out there. The creditor files a creditor's claim, DE 172. The executor, administrator, You allow or reject each claim with a separate form, DE 174. These are filed with the court. Rejected creditors generally have 90 days to file a lawsuit. They can file a lawsuit and say, well, you know what? I think we're owed $10,000. And the executor says, I'm rejecting your claim. And they say, well, we're going to file a lawsuit. We want to get paid our $10,000. So it's very important. What if there isn't enough money to pay all the creditors? And if this is you, I'm sorry to hear this. There's a priority of payment. You have to keep immaculate records. You need legal advice on this because some creditors have priority over others. Last illness, funeral expense, burial expense have priority over others. The federal government has priority over everyone, even including the lawyer and the lawyer's attorney's fees. So if you end up dying with a big federal liability, if you took out an EIDL loan or a small business administration loan, death under many of those notes with the SBA and the EIDL loans, death is a default and all that money's due, and the federal government is a super creditor. So very important to understand if you've taken out an SBA loan or an EIDL loan, really think about getting some life insurance to cover the death benefit if something happens to you. So step 8, taxes, personal income tax, fiduciary, property tax. You file the decedent's final return, which is the Form 1040, and other California returns as needed. If the estate earns more than $600 in income before closing, the fiduciary return or the 1041 is due. In California is a 541. The general federal and franchise tax board rules apply if the gross estate requires it, meaning for deaths in 2025, if it's over 15 million, you've got to file a federal estate tax return. And for California real property, make sure the BOE 502D change in ownership filing is handled if you have an LLC. So if you have an LLC, slightly different, you're notifying a different agency. Accounting and petition for final distribution. Finally, we're getting close to the end of probate. You prepare the formal accounting unless it is waived, but you still have a petition to close the estate that has a bunch of information in it for the court. You file the report and petition for final distribution. This tells the judge exactly what came in, what went out, what remains, who gets what, and requests statutory fees, which is the fee for the executor administrator and also for the lawyer. And you file your notice of hearing, Form DE 120. If you can't finish the probate within 1 year, and many don't. Now, as a lawyer, we don't get paid till the probate's over. So guess what? We're really interested in getting this thing wrapped up just as soon as possible. But for sometimes you can't for a lot of different reasons. If you can't finish within a year of letters or 18 months if an estate tax return is required, you must file a verified status report explaining why and when you'll finish. The judges don't love radio silence. In fact, I've seen judges calendar when they issue their order for to open the estate, they will calendar 1 year later an order to show cause why the executor should not be removed for not completing the estate within 1 year. Okay. So that's out there. So just understand that once those letters are issued, which is typically a couple of months into the process, you have a year to finish it. A lot don't finish in the year. And then they have to file a separate status report saying, hey, this is what's going on. We haven't been able to sell the property, whatever it is. Hearing on final distribution. It's almost over. It's almost over. The final distribution, the court reviews your accounting, fee requests, distribution plan. If it's approved, you get an order for final distribution. Then you can give the heirs their money, the beneficiaries their money. You can distribute the assets. And that may be 2 years. It may be a year. It may be the quickest we've ever seen it realistically is maybe 8.5 months. That's if all the stars are aligned and everything goes right and there's not a lot of drama. But probate, oftentimes there is drama. So. And then you close the estate. After distributions are made and receipts are obtained, you file an ex parte petition. So it's not a noticed hearing, just file it with the court. Ex parte petition for final discharge and order, DE 295. This formally closes the estate, discharges the personal representative executor. And a lot of attorneys don't do this. So if you had a probate, I've seen a lot of attorneys, once they get their check, they're on to something else. They don't do this. This is we're done here stamp. It's over. Stick a fork in it, probate's done. Now, snags to avoid, missing your publication. This delays a hearing or potentially a removal issue if you have to if you're selling real estate and don't publish and mess stuff up. Late inventory, delayed hearing, or removal. If you don't file your inventory timely, again, that judge can remove you for failing to file a timely inventory. Skipping the BOE 502D. This is, I'm not going to say this is up there with tax fraud, but if you have an LLC and more than 50% changes hands or more than 50% acquire an interest in that LLC, oftentimes that property is reassessed. So you need, that is something that where you have to notify the Board of Equalization. I think this one, I'm not sure many probate attorneys understand this, honestly. The wrong authority for a sale, objections and do-overs, right? You have limited authority and you go and sell the property and then you're not, 2 days before you're set to close escrow, the escrow says, wait a minute, you have limited authority. Where's your court order? And then you lose then you lose the buyer. Ignoring the 1-year status report rule. I see this happen a lot. I've sat as a temporary judge in Ventura County in probate court, meaning the probate judge is on vacation. And I've sat as a probate judge and I've seen all this stuff. I've seen people, well, this probate's 3 years old and you haven't told us what's going on. That's bad news. You gotta pay attention to that. Why having an attorney matters. Some people want to do this on their own. Some people realize, what, this is just too complex to have to do on my own. It's just not going to happen. The law gives you flexibility with full authority, but expects precision. There are deadlines, notices, referee appraisals, creditor choreography, right? Figuring out who to pay, when to pay, tax filings. A good probate attorney keeps the process going, keeps you on a tight timeline. Fees are set by statute. It's a percentage of the estate, which we'll go over. An attorney can prevent small mistakes from becoming big ones and really big delays. And with probate, a lot of these run consecutively and a lot run concurrently, meaning one has to happen before the other. So why is probate so bad in California? Why is it so bad? It's time consuming. All the stuff we talk about realistically takes 16 to 24 months. The fees are 4 to 8%. Can be as high as 100%, and we'll show you why. Probate's a public process. All of those documents we talked about are publicly available information. Anyone can walk in and say, who's inheriting? How much are they inheriting? What date are they inheriting? How much did that house actually sell for? Which, you can probably get on other publicly available databases. All of this is public, and this is very creditor focused. Probate is all about paying creditors. A living trust is all about getting assets to your loved ones. So having only a will in place means probate court. A probate on $1 million estate, $23,000 to the executor or administrator, $23,000 to the lawyer. This is even if the house has a $950,000 mortgage, $50,000 in equity. By the time you sell the home and pay the realtor commissions and then pay these other fees, there's not going to be anything left. A $3 million estate pays $43,000 in attorney's fees and $43,000 to the executor. Now, these are the maximum allowed by statute. Most probate practitioners aren't going to do this for less than the maximum amount because a lawyer's going to work for 2 years and then get paid. So think about that. Would you want to work for 2 years and then get paid? No, most people don't. And so that's why you will not see much discounting with lawyers. $10 million estate, $113,000 to the executor and $113,000 to the attorney. We have a probate fee calculator on our website. There's a link here on our YouTube page, and I would encourage you to take a look at that. So that's our probate fee calculator. And once you get over 25 million, it's a different calculation. We do see those. We see a lot of estates in the 5, 10 million, 1 million, 500,000, whatever it is, a whole range. But there are people that have very large estates that never get around to doing a valid will or trust. I mean, look at Prince, $150 million estate. So probate is, would you rather go across the Golden Gate Bridge or some really weird rope bridge from Indiana Jones movie? I think I would rather take the better bridge, right? So living trust, much better way to go. Probate, yeah, it's the rickety bridge, but with an attorney, they can help you through that. But simply much better to go through on the Golden Gate Bridge. Creditor exposure from probate. The notice of probate gives creditors an open invitation to file a claim. So it's published in the newspaper. They're also entitled to notice if they're known or reasonably ascertainable. So These may not be legit creditors, but you have to address them. Prince had 29 different parties filing claims, alleging everything from long lost siblings to business associates supposedly owing millions through verbal agreements, right? And this happens in the music industry. If you're recording a song, you go, hey, we'll split it 90-10. And then you kind of work it out. This is not uncommon in the music industry. In California, creditors generally have 4 months from the appointment of a personal representative to file their claims. In a trust administration, no public notice is required. Creditors are not automatically alerted of the decedent's death. There's no statutory creditor claim window like there is in probate. Creditors must take extra steps. And in fact, if they don't do anything after a year, all claims are barred. All statutes of limitation are shortened to 1 year, not necessarily the same with probate. So let's look at creditor exposure. Mary has a $900,000 estate. It goes through probate. You got to publish notice to creditors. An old business partner the family's never heard of files a claim for $85,000, saying Mary owed him money from an informal loan decades ago. Additional scam creditors reach out. I mean, think of all the scam calls we get on our cell phone now. Just imagine that now there's probate and all this public information. Probate requires all claims have to be formally responded to. They're settled or disputed. The probate fees are $40,000. So the learning lesson on this is probate invites all creditors, even the ones you didn't know existed, to come forward, often with old, questionable, or hard to verify debts. This costs the estate time, money, and takes a huge emotional toll. And a living trust offers some creditor protection. Now, a living trust does not offer creditor protection, I will just say. But when you die, your estate doesn't go through the court-supervised feeding frenzy for creditors. So it's not out there in the public. I suppose it's hiding in plain sight. But probate is an open invitation to fake creditors to scam people, to scam you, to scam your family. This the lowers cost of probate fees. A living trust lowers the overall cost in terms of dealing with these creditors and makes the process private, not public. So a living trust is private. Very important. A revocable trust doesn't protect your assets from your own creditors while you're alive, but can be structured in a way so that when you leave assets to loved ones, maybe your children, it protects those from creditors, predators, and divorce. That would be the future ex-son-in-law and future ex-daughter-in-law. Benefits of a living trust. So how do trusts avoid probate? If you're in probate, sorry, this is like, we should have done this. But if you're in probate, you go, well, I don't want this to happen to me. How do I avoid this? A living trust is like a bucket with a handle. Now, you as trustee hold on to this bucket. You put your stocks, your bonds, your mutual funds into the bucket. Your IRAs, your 401ks, your annuities, your life insurance stay out of that bucket. When you stop being trustee, let's say you die, that bucket passes to your successor trustee. You let go of the handle because you're dead, and your successor trustee picks up the handle, and that successor trustee becomes the trustee. So we drop the term successor. So you may see somebody identified in a trust that says, oh, this person's successor trustee, but when they act as trustee, they're not using the term successor trustee because that means someone who's kind of waiting to be trustee. They are the trustee. The benefits include privacy. Again, we talked about this. Probate's public. Living trust is private. Avoidance of probate court. Look at all the hassle you have in probate court, all those forms, all that time, all that headache. For what? To protect creditors? Like, that doesn't even make sense. Minimization of taxes, right? Sometimes a trust can have different ways it's written, certainly with married people, or when you're thinking multi-generationally with a dynasty trust. I've created a trust that when I die, it's a dynasty trust so that those assets can grow. So when my kids pass away, it's not taxed in their estate, right? Other benefits include creditor protection for your beneficiaries, the people who inherit, protecting the estate from future creditors, predators, and divorce, future ex-sons-in-law and future ex-daughters-in-law. And living trusts are better than probate of a will is basically what it is. Let's look at Avery and Baylor. They create a living trust. Avery and Baylor transfer their home and rental by deed to the trust. The title to the property reads, Avery and Baylor, Young, trustees or successor trustees of the Young Trust dated March 27, 2025, and any amendments thereto. Avery and Baylor, and the bank accounts slightly truncated. So in a deed, we'll typically say, so-and-so, Avery and Baker Young, trustees of the Young Trust dated March 27, and any amendments there too. That's simply too long of a title to go in a bank account. So we say Avery Young and Baylor Young, trustees of the Young Trust dated 3/27/25. The bank also may ask, who are the successor trustees? So if somebody shows up with Avery and Baylor's death certificates and they go, I'm the trustee, I'm the successor trustee, that bank's like, well, wait a minute. We want Avery and Baylor to tell us who the successor trustees are. So just that's something to be prepared for. They may ask you for that when you go and put that bank account into your living trust when you go to the bank and fund your trust. So transfer of brokerage accounts, IRAs, LLC units are similar, but not IRAs life insurance. And so what we have here is Avery, this kind of a schematic, Avery and Baylor. Baylor dies, Avery's alive. We go through something called trust administration, but the assets are held for Avery. So Baylor dies, everything goes to Avery. When Avery dies, we go through trust administration again. So it's like trust administration is like a shortened version of probate, because you still need to figure out who the creditors are. You still need to remove people's names. You know, when Baylor's dead, Baylor's name should come off as trustee of Avery and Baylor's trust. And Avery should be on there as sole trustee. Likewise, when Avery passes away, the successor trustee goes on title, removing Avery's name. And then it's transferred to the three children, Cameron, Dylan, and Emery. Well, that brings us to the end of our time together. We do have office locations in Northern and Southern California. And if you're watching this on YouTube, please subscribe to our YouTube channel. And we now will do a Q&A, but we're not putting this on YouTube. So if you have a question, you can put it on the notes section or comment section, or you can come to one of our webinars and ask questions live. But thanks for watching. Keep watching. Another video is going to roll up right after this one.